And welcome back. The families and survivors of apartheid-era gross human rights violations, together with the Foundation for Human Rights, say they strongly oppose the government's application, scheduled to be heard on Wednesday, to delay the constitutional damages case they have brought against it. The case, filed by 25 families and survivors of apartheid-era crimes on 20 January this year, seeks to have government's conduct in obstructing the investigation and prosecution of apartheid-era cases referred by the Truth and Reconciliation Commission to the National Prosecuting Authority declared unlawful and in violation of the applicant's human rights. In its case, the state will be requesting either a postponement or a stay of the main application pending the outcome of a commission of inquiry established in May this year. The survivors and families, however, argue that the commission of inquiry lacks authority to adjudicate rights violations and may only make recommendations to the president, who is both a respondent in the court proceedings and a key figure in the commission itself. For more on this, we're now joined by the Executive Director for the Foundation for Human Rights, Zaid Kimmie. Zaid, good evening. Thank you so much for your time. Really do appreciate it. Contentious case. First, you bring your application earlier this year, and then after the fact of that, the president announces that he's establishing a commission of inquiry, seemingly in response to your case. And this commission of inquiry is to establish why there have been delays and what to do about it. And in response to your application, former President Thabo Mbeki brought an application to join as a respondent, seemingly to try and defend his name to it, because one of the cited pieces of, I guess, the literature references to the case is a book within which Thabo Mbeki is blamed for some of the delays. The court then says to him, hey, no, it's not necessary. No one's substantively accusing you of anything. And now you bring this case. Well, and then now the government officially responds to your case and says, we want a stay on the main application. That is to say, we don't want this case to be heard until the commission had completed its work. Quite a lot happened in the last 6 months. Why is that stay not appropriate, according to your argument?
Well, first, the commission of inquiry that was established was as a direct result of this court action. So part of the settlement negotiations with the government was that this commission of inquiry be established. But unfortunately, we then differed on exactly what the scope of that inquiry ought to be. In particular, we believe that the inquiry should focus on exactly how this interference happened, who gave the instructions, who followed the instructions, and which people, if any, can be held culpable for this failure to fulfill their legal and constitutional obligations. We believe that the issue of whether harm has been caused, whether the rights of the families and others have been violated, that does not need the detail of who exactly was responsible. It is, we believe, obvious from the facts at hand that there was suppression and political interference in the prosecution, and that's sufficient to recognize that the family's rights have been violated. And we believe that a court is best placed to make that determination, and then also to make a determination on whether or not constitutional damages should be paid and in what amount.
So if one of the terms of reference of this commission of inquiry were to be same as instructed by the president, please determine a monetary value that should be paid to families whose constitutional rights have been violated in relation to their cases having been interfered with. Would you have withdrawn your application of January this year?
No, I think we are going to persist in saying that a commission of inquiry is there to investigate this complex matter of how political interference occurred. The fact that it did occur and that harm has been caused, we believe, is already been established. So for us, the commission of inquiry is still important because we still need to know what happened, and we hope that people who broke the law in not prosecuting and investigating these cases will be held culpable, and that information will be used by the MPA in further prosecutions. But the question of constitutional damages is separate. So we've never accepted that a commission of inquiry can deal with this issue of constitutional damages. We think it's inappropriate. And we all know that commissions of inquiry make recommendations. And if the president, to whom they make these recommendations, does not feel compelled to act on them, then all we'll have experienced through this process will be a delay, because we'll be back in court to push that issue. So we think best settle it now and leave the Commission of Inquiry to focus on the details of how this interference happened.
Before even the start of his first administration, President Ramaphosa had appointed Advocate Moen Cronje to set up a division within the NPA specifically to look at apartheid-related crimes. She had subsequently resigned, but we've seen since then the Amat Temor case make its way to court and the Galata inquest begin, for instance, which is proof that the NPA has, or at least is working towards building the capacity to bring complex apartheid-era related crime to the courts. Should we not rather focus on strengthening those efforts and should perhaps your application not compel a government to be able to make resources available for those prosecutions to actually happen, rather than asking the retrospective questions, how has it not happened?
I think both are important, and this is not an either-or question. We continue to support the families in their quest for justice, in the quest for prosecutions, as is the case with the COSAS 4 matter, or Nokutula Simelane, or Caiphas Nyoka. And there are other matters that are coming up for inquest. So we continue to support that quest for truth and justice. At the same time, the families have experienced harm because people did not do their jobs. They did not fulfill their responsibilities. That may not be of the same order as the original crimes, but there are still significant violations of constitutional rights and a significant betrayal of what the TRC stood for. And we think it's important, because all too often we see people committing wrongs and not being held to account for it. So we think even after all of this time, it's important to hold people to account so that we can understand how this happened and we can put in place measures to ensure that we don't have to go through this again. The next time some issue comes up and there's political interference in the prosecutions, we don't all have to shrug our shoulders and say, well, that's just too bad. Hopefully we can start thinking about what the solutions are as part of this Commission of Inquiry.
Yeah, Zaid, thank you so much for your time. Really do appreciate it. Zaid Kimmie,
Thank you.
Executive Director of the Foundation for Human Rights.